Good morning, welcome back. Thank you so much for staying with us. You're watching Morning Cafe. And this morning, we are going to the corridors of justice. We want to delve into the complexities surrounding customary marriages in the country. And of course, just access to justice for women in customary marriages. To help us with this conversation, we have Silas Akira, that is an advocate of the High Court of Kenya, basically to just highlight the silent vows and shattered rights and the fight for justice in customary marriages. So I invite you to be part of this conversation on our social media platforms, TV47 Kenya on Facebook and on YouTube, and on X at TV47 News KE. There will be a number on your screen shortly. We invite you to also call in. Wakili is here to answer all the questions that you would have this morning. Karibu sana to studio, Wakili.
Thank you very much. Morning to you.
All right. I want us to just start by addressing the fact that, you know, a lot of couples, many couples in this country are in the customary arrangement, you know, but we also have the legal aspect to it. So when one is in this customary marriage, of course, there is no registration to it. How does the law currently recognize such kind of unions? And before we even get right into that particular question, you know, it's right to also just highlight what a customary marriage is, because I know different cultures, they have ways in which they call it. For us, I understand people might think it's ratio, coito, nyombo, like the Luo call it. But is it really the ratio and nyombo, or is it the aye? Just, you know, going to visit the parents and saying, I've seen a flower and this is the one we want to take. Just start from that point.
All right. A customary marriage draws its legality from the Constitution of the Republic of Kenya, particularly Article 159 2C, that recognizes customary laws. Now, there were certain rules, guidelines, and policies that were in practice before the written law came in amongst many communities in Africa, or say largely across the globe. So when you look at the definition of a customary marriage as per the Marriage Act, remember the Marriage Act recognizes and celebrates several types of marriages. One being the Hindu marriage, Islamic marriage, Christian marriage, civil marriage, and then we have the customary marriage. Now, a customary marriage is a marriage between one man and more than one wife.
So basically it's open to polygamy.
Exactly. Really, that is polygamy. But again, there can be customary marriage between a man and a woman, not celebrated in the other aspects of marriages. You can celebrate your marriage, two of you, but customarily, using your customs. The recent example is the celebrated musician Prince Indas sort of opulence that we saw.
Yeah.
That was done in accordance with the customs of his community. However, if you do a customary marriage, then you know there are limits of each and every given marriage. For instance, the Islamic marriage, you have to go up to 4 wives. Beyond 4 wives, then you're limited. Civil and Christian marriages are similar, just one man, one woman, to the exclusion of all others. When it comes to customary marriage, you can get as many as you can as a man. But remember, in this very studio, we had discussed in the past the question of bigamy. A woman is not allowed by law to have more than one husband. That would be called bigamy, and it's an offense, actually a criminal offense in the Republic of Kenya. But a man can have more than one wife, and within the customary setups. But outside the customary setups, you're not allowed to have more than the limits presented by the kind of marriage you celebrated. So, when we delve into customs, remember, first of all, there is the blessing of parents and relatives. A girl and a boy, a man and a woman may meet out in the field, or in some customs, when a lady is of age, a man is of age, they are put aside, the families negotiate on their behalf. However way it may be, our laws and actually literature, the most celebrated literature is the Halsbury's Law, several editions of it, indicate that there are stages to consummating a customary marriage. First of all is that consent between a man and a woman, and then they meet and present some sort of an offer. I am willing to take your daughter. I am up to be taken by so and so. So this is what some people normally call a year. Some call them ratio. You go take something to the girl's parents. Majorly, it is the girl's parents. Once an approval is granted by individual families, then you allowed now to proceed for the actual consummation of this marriage. That is the post-celebration or post-ceremony intercourse. Immediately, you complete all the required customs. You've taken the dowry, you have taken whatever token is required by the elders, and then you are now about to start living together. The law of the Republic of Kenya, now the Marriage Act, requires that you must present yourselves to the registrar and register that marriage. So therefore, all marriages in Kenya since 2017, be they Islamic, be they Hindu, be they Christian, be they civil, be they customary, must be registered and a marriage certificate issued for that marriage to be recognized as valid. And therefore, there is no marriage without a marriage certificate, whether customary or civil or Christian or Hindu or Islamic. There must be a proof of a marriage certification. Otherwise, the consideration would be you are in a come-we-stay sort of or type of marriage. Arrangement.
So when you're talking about one has to present, these two, they have to present themselves, you know, to court for registration. But can somebody go 4 times or 5 times, say a polygamous man? How many times is a man allowed or a couple allowed? This man, because let's say he's the one now marrying these many wives, how many times is he allowed to present himself to court saying, I have this one, the next time he comes with another one and says, I have this one? Is that allowed?
Whereas there are limits, as I've indicated, on mostly Christian and civil marriages. And I said that it's a marriage of one man, one woman to the exclusion of all others. In the customary marriage, there is no limit. You can have as many as your customs allow. Whether 100 or 120 or even the Solomonic 1,000 as your customs allow. But if your customs have capped a limit and then you indicate that you are marrying under customary law, then that will also be challenged. Because everything you do customarily is weighed as against your customary laws. Each and every community's customary laws. There is no singular, uniform customary law applied in Kenya. The Kenyan justice system applies each and every community's customs as they are. And the experts who are now the elders, or those who have extensively studied your community's customs, can be called to corroborate how the customs are applied in your community.
But you know, even as we talk about people should be presenting themselves in court, there is still a barrier when it comes to registration. A lot of people are not intending, you know, to formalize their marriage. This is the customary marriage. What barriers exist in regards to that? What wanaona tu kama is okay. Once the dowries have been taken to the girl's home, then that's it. So what are the barriers that exist? And I'm assuming that you've encountered this in the corridors of justice. What do you see as the main issue as to why people are so reluctant, you know, to formalize these marriages?
Yeah, really, you know, there is the campaign by the religious sector. We talk of the Islamic sort, and we have the Christian. Islamic gives you until 4. Christians say it is but one man, one woman. Now, and you see, Kenya, for example, we are largely Christians. Whoever goes to a customary setting or setup is probably propelled by 1 or 2 factors, and one of them being financial stability. And a man who is able to man 1 or 2 women is said in the society to be somehow financially muscled. And so you find that wife number 2 moving downwards are not secure in these marriages. And they are waiting for the depletion of the muscles, which we call finances, and then they can always bolt out. So that is the major drawback and reason why mostly wife number 2, 3, 4 going downwards are always reluctant to commit to a registered marriage, because they know anytime
it can go.
It can go.
Let's get this call from Dorothy. Okay, we lost Dorothy. So when you're talking about the second wife going down, being so reluctant because maybe they feel like it's secure, then what should they do now to protect themselves and just feel safe in this marriage? Because I'm assuming that, not assuming, it's a fact, once they're there in that marriage, then they're putting all their energy, their mind into this marriage. Of course, it's a lived experience. Then what can they do now to protect themselves from lack of security in this marriage?
You know, like I said, after 2017, all marriages in Kenya were commanded to be, or rather directed to be, registered. So the only proof that you are married to this man is not the celebration of your customs to the maximum, but the registration of that marriage and a copy of the registration certificate deposited with the registrar of marriages. That is the only security you'll have. However, like I said, some of them are also there for the muscles. When the muscles are gone, they feel they are free to leave. And so now they do not want to do what? To do the registration. But in a parting shot, I would say, non-registration is comfortable until the man dies.
Let's get this call. Dorothy is back before she escapes again. Dorothy, good morning.
Hi, morning.
Yes, talk to us.
So I've been married to this guy for 2 years, and we have a kid. And he has been telling me, of course, tuko kwa ndoa and all that. But you know, he has a wife.
All right.
So is wakili telling me that iwe tu siku moja huyu mwanaume akufe, mtoto wangu atapata urithi wa babake. And I've named this child even after the father.
All right, that is Dorothy.
I get the question. Now, Dorothy needs to inspect the marriage itself. First of all, if this man has another family, find out how his first family came to be. Is it Christian? Then Dorothy is no wife and cannot be wife until the Christian wife is divorced. Because I said, Christian and civil are a marriage between one man and one woman to the exclusion of all others. So a Christian marriage cannot be a potential monogamous marriage. But a monogamous marriage can be a potential Christian marriage, because you can have your polygamy by law. Of course, by Christian customs, that is not allowed. But by law, you can have your how do you call them? So many wives, until the point now you decide to contract one, a Christian. So anybody afterwards is excluded. Now, the only thing that can save Dorothy, if a marriage certificate is made. Otherwise, the relationship is strong between the man and his child. But the man and Dorothy, the relationship is very weak.
All right, thank you so much, Dorothy, for that question. But Wakili, what rights exist, for women in these arrangements, the customary marriage, in regards to inheritance, burial rights, and of course, property as well? What rights do they have?
Well, a woman married under customary is as entitled as a woman married under any form of marriage when it comes to property rights. They are.
Just a minute. Dorothy is back,
Okay.
and she has another question. Dorothy?
I've had the wakili, but now hajinijibu. Will my child get inheritance? Huyu mzee siku moja akufe?
Okay. Will the child get inheritance?
Exactly. Children are not affected by marital status of the parents. The only thing that needs to be proven is that the man is the biological is the biological father of the child. And children must not prove dependence. While others like uncles, brothers, fathers have to prove that they were depending on the man prior to his death. A child, whether from Dubai or from where, the moment he comes to seek inheritance, there is not going to be a lot of debate. The only thing you need to prove that this man was my father. You will be entitled to equal share of the estate, just like the ones that the man was actively taking care of. You may have been neglected somewhere as a son, but then you realize that your father is dead, there are assets and succession is ongoing. You just raise an objection, prove you are a son to this man, you will never be subjected to so many scrutiny. The estate will be split in equal share among the sons, so the children and the wives that the man has.
Dorothy, did you get a good answer from Wakili?
Yes.
All right.
Now, how do we stop easy mambo? The husband anataka kukuficha, and wewe uko pale, you want to protect yourself from the other side of the family. How can you protect yourself from all that?
Yeah, Dorothy, there are two things which are going to help you here. One,
Nukumbuke the man anataka kunificha kabisa.
Okay.
There are two things that are going to help you here. One, and of course it might work to your detriment if he's also following us. You're seeking legal advice, and he might also be seeking legal advice. So one, you have to ensure that at least you have a record of DNA, paternity test between the man and the child. At least maintain the record. And the record should also be available to the forensic examiners, the DNA testers in the country. Number two, ensure that the child's birth certificate really is in tandem with the man.
That is the name?
Yes. So ensure that that happens. With those two records, you're okay. Anytime, but we are praying for his father's long life, because in as much as anataka kumficha, then it means in one way or another, he is somehow committing to silent provision for the child. Yeah, that such kind of a man can be celebrated. Not like one who abandons completely, but like I said, only those two will save Dorothy's child. A DNA record a record of the DNA, and then the birth certificate. Yes.
But Wakili, I hope Dorothy is still on the line. Maybe if she's satisfied, we can now proceed. All right. But you know, Wakili, I was listening to a certain video online of another Wakili saying that children are not guaranteed inheritors of their parents' properties. So in this particular case, when we're talking about a customary marriage, and the other video is talking about a child is not guaranteed to inherit that property, then does that come to play, or how does that actually work when it comes to a child inheriting now the parents' properties?
We have so many lawyers and so many experts of law. But one thing I normally advise some of my clients is that as the law was developing, you'd put on your wig and your nice gowns and with your briefcase, move to court and argue a case based on logic and win. Today, you would go with logic, the court will listen to you. After that, the court will ask you, counsel, what does the law say? So everything is in accordance with the law. I am guided by Section 29 of the Law of Succession Act. Also guided by Section 66 of the Law of Succession Act. These two grants you or categorically stipulates who are dependents or beneficiaries of a deceased person's estate. They are grouped into three. Number one are the wife or former wife, wives or former wives, and children. These ones must not prove dependence. Ati, he used to pay my fee, he used to do what? No. You only need to prove that you are the wife. How do you prove you are the wife? There's a marriage certificate, not customs. There is a marriage certificate. How you celebrated it, the law appreciates. But proof that you are married is a marriage certificate. How do you prove you are a former wife? It's a divorce certificate. It's a divorce decree certificate. So once you have this, then you don't need to prove that, we live together, we had children. A child, birth certificate is there, and then paternity test. Also availed. This person is entitled by law. Group number two are the groups of the parents, now my father now, or my mother. The groups of grandparents, brothers, uncles, nephews, but this category must prove that before I died, I maintained them. I used to send sugar, and so my demise is actually somehow going to affect them. You understand? Yeah. Then the third group is now a husband of a woman who is dead, but they were previously married. Yeah. Remember, group A is about wife. We are contemplating the death of a man. Yeah. Group C is now a husband. We are contemplating the death of a woman. But group B, Group A and Group C must not prove dependence. Group B have to prove dependence. So the child, wherever born, neglected, abandoned, has a right. There is a guarantee by law. I'm guided by the law. There is a guarantee.
What does the law say?
The law says, if you allow me, I can read it.
Yes.
Please. Section 29 of the Law of Succession Act. That is what I want to read here. Yeah. 29.
And of course, you're saying that is what the jury will ask.
Exactly. Exactly. At the end of it all. For the purposes of this part, dependent means the wife or wives, a former wife or former wives, and the children of the deceased, whether or not maintained by the deceased immediately prior to his death. You understand? Yeah. So maybe the context counsel was talking about in that clip is the guarantee in the sense that the child will have, first of all, to prove that this was his father.
Okay.
But once it is proven that this was his father, I assure you,
Guaranteed.
it is guaranteed by law.
You are addressing the question of the rights, of a woman in customary marriages in terms of property distribution, say burial decisions, and even inheritance rights. Before we got that call from Dorothy, maybe you can pick up from that again.
Yeah, really. And I had indicated that similar to other marriages, a woman in customary marriage is as entitled as the others to the property or the estate of their deceased husband. Now, the only problem, remember I said, non-registration of a marriage is only comfortable or is comfortable until the man dies. When now you begin to tussle over property. You go to court, you say, oh, I lived with him for so many years. The court will ask, where is the proof that you are married? Oh, no, cohabitation. Cohabitation is slowly being outlawed, if not, has been outlawed in our country. The come we stay. Remember, there is no former concubine, former girlfriend or concubine, from what I have read. It is categorical. Wife, wives, former wife, former wives. So you have to have proof that you are married to this man immediately prior to his death. Then nobody will have a right over you. And remember, the parents of the man, the other relatives of the man, have secondary right to the wife. The wife, in terms of inheritance, has been given primary right in terms of inheritance. However, when you talk about burial rights, if this man had a home, right, then the wife would be given priority. However, if this man had no home, and the wife is making a decision as to bury the man to a cemetery, or buy some land somewhere and bury the man there, yet the relatives are strongly advocating for the man to be taken back, wapi? Nyumbani. We have the SM Otieno case, one of the most celebrated cases in our country. Customs of the man will come into play, and the man will have to be taken back home to his kinsmen. However, if the man has a home somewhere where they are staying together with the wife, then the primary decision maker in terms of the burial place will be the wife.
What if there are many wives, they say 2 or 3, now how do these two make the decision now in regards to maybe the burial rights for this deceased husband?
They can agree, but if they fail to agree, there is a tussle, then the customs of the man's community will come into play. So there you will find that the man will be buried at the first wife's home. In most customs. There are those other customs which I have not yet known, but there could be one that gives the last wife priority. And so if the custom gives that, and you can prove that in court, you'll have the body.
Walk us through the kind of evidence that the courts look for when validating a customary marriage. And I know you've talked about certificates of marriage, but is there a chance where, or an instance where a court has compromised and said that this is a valid reason as to why we should say that you are entitled to 1, 2, 3 because now you are part of this man's life? Is there a point where court has compromised?
Yeah, circumstances bring different decisions from court. For instance, you've celebrated every aspect of the customs of your community. And then, God forbid, or unfortunately, on your way to undertake the registration, the man dies. What was the intent? Marriage. So in this, the court will consider and confirm the marriage. Because the man was on his way towards completing the processes. However, you have lived for more than 20 years, and the law has indicated that certificates have to be obtained from the registrar of marriages. But then you dilly-dally, and then you come to court that, please, we have lived for 20 years. Confirm marriage. The court will decline. Understand? Ignorance of the law is not a defense, but circumstances must also be taken into consideration. Why don't you have a marriage certificate? Understand?
Yes. Now, in that case, you say that court can compromise if maybe they were in the process of now formalizing this marriage, and then unfortunately the husband dies. Is she entitled to inherit in a case where they're still new into the relationship, there wasn't any financial contribution from the wife maybe, but now there was a first wife in this particular, arrangement or marriage? Is this second wife now entitled to marrying if court compromises in that situation?
While judicial or quasi-judicial bodies are entitled to make decisions, any decision by a court of law in Kenya is considered supreme. Understand? A court of law can void a marriage certificate. Void by voiding means cancel it. A court of law can reinstate a cancelled marriage certificate. So if the court has ordered that this is a valid marriage, there is no authority, agency.
Just hold on there. We have a caller for you. Waweru, good morning.
Yeah, morning. How are you?
Good, Waweru. Good to hear from you. Talk to us.
Yeah, I'm calling from Kwadio Kayole.
The
other day there was a query from the judicial system about people who have stayed more than 3 months. They are considered to be already married. How does that apply in this situation? That when everyone goes to the court, just for having stayed for more than 3 months.
Okay.
Yeah.
Wakili, how does this now apply when one is already married with very many wives, according to Waweru?
When the man is married to very many wives,
yes,
the man will have many marriage certificates, but each wife will have only one. So it is the marriage between me and you, me and the second wife, me and the third wife. So each and every marriage will have to be formalized. So in the end, like I say, the man will have many marriage certificates. If there are 10 wives, then the man will have 10 marriage certificates, but each wife will have just but one marriage certificate between her and the husband. Understand? So, for customary, if you've married from 10 communities, it will be considered not with regards to your community. If you decided to marry with within the customs of each and every wife's community, you understand? But if you decide to marry in the customs of your community, all the marriages will be considered within the customs of your community. But if it's for each and every wife's community, the community that celebrates the custom is what is considered in the court of law.
All right, Waweru, I hope Wakili has given you a satisfactory answer. If not, we are very much happy to hear from you once again. But of course, Wakili, you're addressing the question of inheritance.
Inheritance rights.
If at all court would compromise in a case where the spouse dies before now they formalize that marriage, then in that case, what happens? Yeah,
like I said, now, once a court of law has upheld the validity of a marriage, there is no agency in the country that can indicate that the court was wrong, other than by appealing the decision of the court to a higher court. So only a higher court can cancel or void what has been held by a court of lower rank. So, assuming now the case is that the court has compromised, within your words, and upheld a marriage that was otherwise voided by law, then the inheritance rights will kick in. If this marriage is under customs but between one man, one woman, then there was no will. And I wanted to come to that because that is actually the hammer of all the problems we have.
The will.
Yes, it is the hammer of all the problems we have. If you're in a customary marriage, the law indicates this, the law indicates that, but the man has a valid will. The will supersedes the minimum principles provided by the law. So if the law says that everything has to be split into equal portions and subdivided in accordance with each wife, number of household, considering the number of children in each household, but your will indicates the first wife has to be given a quarter, the second wife will be given say a quarter also, the third wife will have a half. I tell you, that is how the court will uphold it.
Amazing. Now, you see, in other countries, we've seen cases where widows are pressurized to remarry so that maybe they can get access of property of the deceased husbands. And that this is, I'm giving a citation from Nigeria. We have, was it Hadiza? Somebody called Hadiza. So do we have such cases in Kenya where, you know, a widow is forced to remarry so that they can now own their deceased husband's property?
No, not really. In the Kenyan context, a widow or a woman has whole life assurance on the deceased estate until the time they remarry. So when you remarry, this assurance typically, because the law does not want a scenario where you gain here, you gain there, you gain there. Our laws really take care of unjust wealth. Otherwise, if it's allowed, today you have this husband, sometimes even some even unalive their husbands for estates, unalive this guy, make away with it, go and unalive another one, unalive another one. No, you will be in a sort of way of unjustly enriching yourself. So that's why in our laws, the woman has whole life assurance on the deceased estate up to the point she marries again. But that is why the people most considered for inheritance, most considered, are the children. Because the moment you get to remarry, it is now a contract between you and the new marriage. What about these children? So that is the consideration of our succession laws. But the Nigerian laws, I'm yet to meet that decision. However, legally, it isn't sound. That you have to be forced to remarry so that you come back to inherit your deceased husbands. Okay, some can say in the context that for the new husband to help you take care of the estate. But really, that is not sound. It is not sound.
Maybe according to the customary laws there.
Maybe probably. That's what I'm saying. I'm yet to get hold of that case, but I would want to appreciate the decision of the jury in Nigeria.
But now you talked about the children now inheriting the property, but we have now communities that are deep-rooted into these patriarchal norms where only a male heir can now inherit the property of the father. But in communities where, let's say, the girl child is the first one, maybe, you know, the little child, Akuko, 1 year old. So what happens in that particular case when the widow is left behind, but the children that are should, the next heir are girls? What happens?
You know, one of the principles of law and that Kenya greatly appreciate is the equality before the law. Nobody is above the law. Nobody is below the law. Everybody is treated equal. And that is why per Kenyan constitution and the subsequent acts of parliament, the lady, a girl, and the boy have equal inheritance rights. unless, of course, otherwise, the father dictates in the will. Like I said, the will is the hammer of all other things.
Yeah.
But where there is intestacy means estate left without a will. The law will treat these people equal. And in fact, some succession causes have not made any progress because the petitioners have refused or dilly-dallied to bring ladies to court, in the succession court. Or some ladies are still held up or still clinging to a patriarchal or customary way of life.
Yeah.
And they are old. They say, no, I am married. What am I coming to do? Like, honestly, I greetings to you, my sister. I have had a bit of problem with my own sister, trying to bring her to succession. She tells me, no, I have my estate where? At my husband's house. Eh? But then, for a lawyer or for an advocate, a petitioner, to convince the women that, hey, the law allows you to inherit from your father, especially the advanced mothers, is difficult. They'll tell you, no, I have no time. I already have my husband's. Niko na nyumba yangu, you know? That's what they say.
Yeah.
Like, you know, apologies. In my community, they'll make it quite simple. Angidalana, meaning I have my home.
Yeah.
So that is what makes it difficult. However, they have an equal right to do what? To inherit.
Yeah.
And where courts note later note that ladies were left out, that grant will be revoked.
Oh, wow.
And they'll have to be included. And if the male had already eaten the entire estate, they will be forced to compensate the women.
Culture.
Yes. So they have a right. So whether the lady is the firstborn and the boy is the lastborn, they have that equal right. But of course, now she'll have to hold the brother's assets in trust. The brother's assets will be kept by the sister in trust until the child, the boy, reaches the age of 18. Or after 18, now she can decide whether to still keep leaving the asset to the sister or transfer them to his name. It will be his own decision.
Now, Wakili, in cases where, of course, there was a first wife, now there's a second wife to this, and, you know, the husband dies, but now the family says, then denies and says that, no, you are not the wife, you know, to your father. Then what happens in that particular case if children are also involved? They knew this wife was existing, but now they deny her, you know, the rights to, you know, come to the burial, to just get access to the properties that the husband left behind. Then is it right to treat this wife that way? Or, you know, what can they do now in that particular case to protect themselves, even as they claim that they were married to the deceased?
Every claim has to be passed through the balance of the law. If you claim you are a wife, what proves?
Evidence.
You must go with evidence. Sometimes I make my clients laugh because I tell them, you know, your story is so touching. Your story is so real. I believe it. You will go make it in court until the magistrate will take out an handkerchief, give you to wipe your tears, but in the end they'll ask you, where is the evidence? We don't go by hypothesis, logic in a court of law. And that's why I said we have so many lawyers, but what does the law say? So if the law indicates that you must register your marriage and all these years you did not register your marriage, then you're coming to claim. If you want a consideration of customary law, let your parents or your relatives corroborate with the parents or relatives of your deceased husband that indeed you are married under the customs. Then argue that in court, tell the court why you did not register, and then see if the court can somehow compromise in your words, and allow you and allow your marriage to be validated, because everything has to be weighed within the balance of the law. And who weighs that? An independent jury.
Yeah.
And that's why we say we have voidable and unvoidable marriages. So any marriage has to be, any claim of a marriage has to be weighed in court.
Okay.
Some even carry marriage certificates, but they are invalid. Yeah, you have a marriage certificate, and you see everything, seals, kila kitu. And then later on you're told this one was produced from River Road. There's a post I made on WhatsApp, and so many were asking me, it was not on WhatsApp, but it was on Facebook. So many were asking me, how do I validate my marriage if it was really registered? And I told them, it is simple. Just apply for a certified copy of the marriage certificate. If it is with the registrar will confirm to you that we have a copy, and this is what we are giving you now is a certified true copy of what we have in our files.
Okay.
Then you will be okay that now my marriage is sealed. But sometimes many women or men hold or carry fake certificates.
From River Road.
Even academic transcripts are forged.
Let's get this one from Lewis. Lewis, good morning.
Hello.
Lois, good morning. How are you?
I'm fine.
Talk to us.
Yes, nilioleka customary
Okay.
for 7 years. Then tuka break na huyu mtu kama tuko na watoto 3.
Okay.
So kuna vitu nilikuwa nimenunua hapa kashamba, lakini it was on his name. So ameoa. I'm good. Yes, I'm Lois from West Pokot. Yes, I was customary married.
Lois, we can't hear you. Kindly reduce we are struggling to hear you. So punguza volume ya TV or just toka mbali kidogo.
I'm Lois.
Yes.
From West Pokot.
Yes.
I was customary married. From my non-tribe. I'm a Pokot and I was married by Marakwet.
Okay.
Oh, this man married for 7 years. Then we had 3 children. Then we broke out.
Yes.
And there are some things we did together. I'm a teacher and he's a teacher. I also bought a land, and I didn't have a written document to say that this was my husband. Then he married. Then we broke out and he took the children. So whenever I go, I don't know who anafanyaje. I don't get justice. So they tell me, show me where is their documents, and I bought the land. How will I be assisted? And my marriage was customary, and already is married, and I don't know, he's planning to marry this wife legally. So I'm a bit bitter. How will I get my portion?
Okay.
Yeah.
Yeah, I forgot her name, but I got what she said.
Lois.
Lois. Lois can reach out because that's a bit more deep legal.
Yeah.
However, on a nutshell, just like you've heard she stated, she has a claim, but they are asking her, show me
Documents.
the documents. Those documents are the evidence. Like we said, if you are married, the only proof of marriage is a valid marriage certificate. Not a marriage certificate, but a valid marriage certificate. And then in terms of assets that you hold together, remember on land matters or any property, if it is joint ownership, the survivor takes it all. Assuming we have a piece of land and we jointly own the land, this land is not going to be included in the estate of the deceased. The claimant is going to indicate that this was a joint tenancy. My partner is dead. I'm the survivor. He will be given the land. However, if they contributed in buying this piece of land, but was registered in the single name or sole name of the husband, and the husband is now dead, they're putting the husband in quotes, is now dead, but then she contributed greatly into the purchase to the extent that by law, this land would be considered hers, and she can prove that. Some title deeds have always been revoked or cancelled if you prove how if you do not prove how the title deed was acquired.
Yeah.
So if she proves that she paid the money, agreement is there, transaction records are there, but then now she's not a wife by law, but she contributed in the ownership of this asset, she can get a portion. Our laws are very just, I would say so.
Thank you so much, Wakili. Our time is done, but of course there's so much to talk about in regards to this.